Welcome to today's presentation on entity authority. My name is Lavinia Biasell, and I am the Chief Legal Officer at Transnation Title Agency. Before I get into specific entity types, I'd like to take a moment to talk about why title agencies are asking you or your customer about entity authority. And it has to do with the title insurance policy itself. A title policy, specifically covered risk number 2, insures a buyer or lender against loss resulting from 1, failure of an entity to have authorized a transfer, or number 2, improper authorization of a document. Both items directly relate to the entity authority an individual has to sign documents on behalf of that specific entity. Unfortunately, lack of entity authority is one of the top areas of title insurance claims. So today I'm going to wrap up our conversation with a specific claim story, which will be a true story, unfortunately. So let's get into the specific entity types and what a title agency needs from you to determine proper entity authority. I am going to start with corporations. So corporations in Michigan are formed by filing articles of incorporation with LARA, which is the Department of Licensing and Regulatory Affairs. A corporation operates in accordance with what we call bylaws and through a board of directors and officers. When a corporation acts, such as selling real property, it needs a resolution that comes from the board of directors approving the sale and authorizing the specific officer of the company to sign the documents to complete that sale. If the real property being sold is all or substantially all of the assets of the corporation, then we will also need the shareholders of the corporation to approve that sale. Next entity is a limited liability company known as an LLC, and possibly the most popular type of entity that we see. LLCs in Michigan are formed by filing articles of organization with LARA. An LLC operates in accordance with its operating agreement and through its members and possibly managers. So an LLC can be member managed or it can be manager managed. And this designation is made in the articles and in the operating agreement. For a member managed LLC, all of the members need to sign the conveyance documents, or they can provide a resolution similar to the one provided by corporations, approving the sale and designating one member to sign for the entity. If the LLC is manager managed, then all of the managers will need to sign or do a similar resolution. Although I would also recommend that an LLC have an operating agreement at all times, even for a sole member LLC. In some cases, sole members do not have operating agreements. In that case, we can accept an affidavit from the sole member indicating that they are the sole member and do not have an operating agreement. Lastly, I will talk about partnerships. To form a partnership, you need 2 or more people. There are 2 types that we will typically see on our end: general partnerships and limited partnerships. A general partnership is made up of general partners. The general partners will act together to sell the real property by signing the deed and any other closing documents, or they can delegate 1 or more partners to sign on the entity's behalf. The title agent is going to require a copy of the partnership agreement, and that will be to confirm those general partners. A limited partnership is created a little bit differently. It's created by a certificate of limited partnership, which is filed with LARA, and is made up of general and limited partners. The conveyance and other closing documents are signed by the general partners, not the limited partners. The title agent will need the certificate and any partnership agreement, again, to confirm who those general partners are. The general partners can designate 1 or more of them to be the signers for the entity if all of them do not want to sign on behalf of the entity. Establishing entity authority is pretty straightforward. So you may be wondering, why is it such a hot area for claims? Imagine a criminal who searches the records and finds a parcel of land owned by an LLC. The criminal is savvy and drafts an operating agreement, resolution, and even obtains a fake driver's license identifying herself as the manager of the entity. The documents all check out, and the criminal sells the property for $30,000. A few weeks later, the real entity owner is alerted, contacts the buyer, who makes a claim under Covered Risk 2 of its policy, and receives a check back for $30,000. We at Transnation Title ask for the information necessary to establish entity authority in order to protect all parties to the transaction and issue a title insurance policy. If you have any questions or need assistance with these documents at any time, please contact a Transnation Title Agency office for assistance.